Every day in the USA, people find themselves in court.
Nineteen 31029 is now called the State of Texas versus Kevin Jones Sr. That's you, sir, with Mr. Samuel, your attorney, and the state's attorney. You have pleaded true to the second amended motion to revoke unadjudicated probation in this case. You were placed on probation originally on June 18th of 2020 in this court for the second degree felony of aggravated assault with a deadly weapon. And you were placed on deferred or unadjudicated probation for 10 years. Here, you pleaded true November 12th, 2024 to the allegation of committing the offense of assault causing bodily injury on or about March 24th, 2024. That was in violation of your probation order, as well as committing the offense, allegation number 8, in this first amendment, in the second amended motion to revoke probation. These are both out of the second amended, number 5, which is labeled first amended, and that was included in the earlier probation motion, probation revocation motion. And then number 8, part of the second amended, was evading arrest or detention of a motor vehicle on or about April 16th, 2024 in Jefferson County, Texas. Okay. Pre-sentence investigation update was prepared, and the parties had an opportunity to review that.
And there's, yes, you got this one. December 11th.
Yes.
Yes.
Well, no, it says date of sentencing December
That was-
11th.
Yeah, that's what you have.
The date of report is November 22nd. Date of report.
Yes.
Okay. That's what we're using on this.
Yes, sir.
And any corrections or changes to it? Dave, or
No, Judge, we went over this once before. There's a recommendation by the probation office at the very last that says that the defendant be placed on straight probation. And since this is an aggravated assault with a deadly weapon, that's
I don't think
possible.
that's eligible. Is it?
Just want to make sure that's clear.
So he was on deferred or unadjudicated probation. He's not eligible for regular probation. So what's your recommendation?
Your Honor, we're asking that he's been in jail now for 6 months. We ask that the court consider that and allow him to remain on probation and intensive supervision. And we believe all of the items that you listed in the recommendation would be beneficial to him. Since he's been in jail, he has had an assessment done by Gulf Coast Health Center. And there were some diagnoses that arose from that. We believe at this time, since he's been in jail for 6 months, he understands the severity of him getting help. In the observation, it was noted on page 4.
Have you seen this?
No, sir. Okay.
On page 4, there's some diagnosis, but because he was in jail, he could not, they could not give the prescription. So we're asking that he be allowed to seek assistance and have him on intensive supervision during this time, or at least the next 6 months, just to show that he does understand and he is seeking the help that he needs. And one of the things we're not using as an excuse, but we like the court to consider in that Mr. Jones has 8 children, minor children, and that's with 2 different mothers, 3, and he is taking care of them, and we ask that the court give him that consideration and allowing him to remain on intensive supervision in the program. I think the probation officer mentioned in her report, her concerns, and she does feel that he can be successful. And we're asking the court to consider that, particularly considering he was going in jail for 6 months, and he had an opportunity to come out and get help. His family supporting him to get the help. So we're asking that the court consider that.
Thank
Judge, I don't know what that report does, the medical report does. It just basically says that he has some issues with depression, anxiety, and I think it's bipolar, but there's a lot of people that survive that.
There's
But
nothing, hold on, there's nothing in here says he's insane.
No,
No.
Nothing in here says he's incompetent.
no.
We're not saying that.
Okay. He's just not perfect, like everybody has issues.
And the problem I have is that he gets out and he's just violent. After being placed on probation for a violent offense. And he's a risk to the community. He doesn't seem to get it. He's had an opportunity where he committed one crime in March of 24, then he committed the other crime in April of 24. They're a month apart. And so he's got issues with this female that in the original case. He's got the second case that we have involves another woman that is one of his love interests, and he just keeps committing crimes. And this is not one of those where you say, well, after 3 or 4 or 5 crimes, after 4 or 5 felonies, we've got 2 new felonies here. You can't just say, oh, well, now we're gonna look for help. He should look for help when he had probation the first time. If it's not serious enough on felony probation with an aggravated assault with a deadly weapon, then I don't know what more he needs other than prison time. And that is to have time and years to reflect on the severity of this crime, not just a couple of months. That's just not enough time for him to be punished for committing crimes outside of probation.
Yeah, Mr. Conrad.
Yeah.
Yeah, I can understand why the state takes that position. However, one thing that is not taken into consideration is the basis of that. If you will notice, each of those offenses were dealing with emotional state. And that is an issue that he's had, that he has not had true opportunity to get help for that.
What
because-
stopped him? Hold on. What stopped him since 2018 to get some help?
So
Well, then he's got to take responsibility.
I
All
understand,
right.
Your Honor. We're simply saying that there is an emotional issue, there's an underlying mental issue that.
He's not incompetent. He's
He's
not
not.
insane.
We understand. that.
He has since 2018, since he committed this offense, aggravated assault by repeatedly striking a vehicle with his own vehicle of the victim. Where he was found,
Yes,
where he
Yes.
was found that there was enough evidence to find him guilty of aggravated assault, but I placed him on deferred or unadjudicated probation. Striking another vehicle numerous times in this town. And it's only a 4,000-pound missile, nothing dangerous, a 4,000-pound missile. And so we place him on probation. Now, what do we do now? He's on probation, knows that this is serious, commits the offense of assault causing bodily injury by choking the victim, choking someone, another one, right? Yes. Then, here's another one. Number 8, committing the offense of evading arrest or detention on a different day when he attempted to flee the police. But here's the problem, is you were put on notice that you can't be treating people, ladies, women, and other people by taking a 4,000-pound missile, a deadly weapon, and repeatedly striking their vehicle with it. We made a big deal about it. But yet, afterwards, you come back and you think choking a lady is the way to perform properly after we made a big deal? No, I don't think so.
Your Honor, I understand.
Wow.
What we asked the court to consider. there's a 6-year cap that has been offered to Mr. Taylor. He could face 20 years. He understands that.
But it doesn't matter. He's not taking that deal. He's not taking that deal. Let's talk about what's on the table.
On the table.
With me.
On the table is a 6-year cap
6-year
on the,
cap.
on the MTRP. The 2 new cases we haven't worked out yet.
Yes. So we're simply asking to allow him to remain on probation. That will give him an opportunity to prove to the court. If he doesn't, he's facing 20 years.
But who's going to get hurt while we wait and see? Because if he violates, he usually violates with something that's
What
violent.
was the
So
date? What was the date?
What was the date before?
November 12th of 24.
Not 10/2/24?
No, that was something else. This was 11/12/24. 11/12, November 12th.
And the problem is the defendant had requested 10 years imprisonment, probated for 10 years that we know cannot be by law allowed.
Right.
So what do you want to do?
We asked him to remain on probation on intensive supervision. And any other considerations that the court might want to add to that will give him an opportunity to show you. If he doesn't, he has a full range of punishment at least.
And the state is asking for
The 6 years, Judge. And if you look at the pre-sentence report, that big pre-sentence report, there's been other arrests. Class A misdemeanor assault, interference with a 911 call. We've had plenty of chances for him to get this under control, and he's just become more and more of a problem.
Let me ask, have you had a chance to review this pre-sentence investigation report that was prepared on November 22nd? 4 months,
Yes.
4 months ago. Okay. Are there any corrections or changes by either party to this?
No, you're not.
Depend. No.
No, Your Honor.
Then it is made a part of the record for this hearing. Does the probation office want to add anything? Okay. Anything more?
The only thing I said, I would ask the court to look at the last paragraph in recommendation. He's shown that he can adhere if he simply does that. Again, he's facing 20 years. He has 6 years on this. And there are 8 children that are also going to be part, is going to impact him. We ask that he be allowed to remain on probation, work, pay his child support, take care of the children, report to the probation officer, and adhere to the conditions of probation. And if by chance he doesn't do that, the court has full range of punishment to revoke him at any time.
Okay. Is this your signature? Mr. John, is this your signature right there? Yes. Okay. On November 16th, 2023. And this was part of the pre-sentence reports, but these are documents that the probation office went over with you. And you had the bar set of what requirement you needed to meet. This was on November 16th of 2023. You promised, there's your signature, and there's your probation officer's signature. I will live a crime-free lifestyle. Well, you didn't do that. I will handle my emotions appropriately when I find myself in stressful situations. You didn't. I will consider the negative consequences before I make a decision. Well, maybe you did, but it doesn't help you make the right decision. You made all these promises, which really are inherent when you were put on probation, inferred when you were put on probation. After you made all those promises, you committed the offense of assault by choking someone and committing the offense of evading arrest or detention with a motor vehicle. Can you explain after you made all those promises, which by the way was the second time you made promises, because when you were put on probation, these were essentially the same promises that you had made to the court that all probationers made, knowing that your probation could be. Can you explain how you made promises again, but yet you didn't fulfill it?
The case is a choking. There's only three true to fit in the choke. Only two.
Wait a second. What are you about to say? Because you were under oath. And I asked you, like I asked all probationers, are you pleading true to this violation of probation voluntarily and it's because it is true under oath? You're telling me that when you said true, you didn't really mean it?
No, I'm not saying.
What did you say?
I'm saying. I'm not saying that I didn't do. You know, what I'm saying is that the charge that I'm being committed of making happen how I said it. That's what I'm saying.
Okay.
Judge, we'll withdraw our plea bargain agreement and ask that this be set for hearing. If that's the way we're gonna go.
Okay, that's what we're gonna do then. That's what the state's asked. The agreement is declined to be followed by the court, and we'll have a hearing on this. Motion to revoke probation based upon the statements made by the defendant. You're not gonna try to trick and maneuver and manipulate the court. That is all. And you're gonna be subject to the full range of punishment now. All right, is there anything else